All rise. Vous vous levez. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez asseoir.
Good morning. Would the court officer please call the case?
Good morning, Mr. President and your honors. Situation in the Islamic Republic of Afghanistan. Situation reference ICC 0217. And for the record, we are in open session.
I note regarding the appearances that all participants present today were already placed on the record yesterday. Unless I'm mistaken, we can dispense with placing appearances on the record. Yeah. Yes, Professor David Sheffer.
Your Honors, David Sheffer, Northwestern University Pritzker School of Law, as an amicus.
Thank you, Mr. Sheffer. Well, yes, please proceed to introduce yourself to the record.
Good morning, Your Honours. My name is Joshua Kern of 9 Bedford Row Chambers. I appear for the Lawfare Project, the Jerusalem Institute of Justice, UK Lawyers for Israel, My Truth, the Simon Wiesenthal Centre, and the International Legal Forum. Thank you.
Thank you very much. We can proceed now.
Your Honour, if I could add on behalf of the government of Afghanistan as well, Mr. Said Mohammed Alemi from the embassy, who has joined us for the hearing today, so an additional member of our team for the record. Thank you, Mr. President.
Thank you, Counsel. Well,
My name is Margaret Satterthwaite, and I appear before you today along with my colleague Nikki Reich on behalf of Mohammed al-Assad, one of the victims, number R0074918, in these proceedings. Thank you.
thank you, Counsel. Thank you very much. We can proceed. Before proceedings with this schedule for the hearing of submissions on the merit of the appeals and the question posed by the Appeals Chamber under Group C of the list, the Appeals Chamber deems it appropriate at this stage of the proceedings to render an interlocutory decision on the question of whether the appeals brought by the victims LLV1, LLV2, and LLV3 against the decision of the pretrial chamber rejecting the authorization of an investigation into the situation in Afghanistan are admissible. The Appeals Chamber has had the benefit of receiving submissions both in writing and orally by the participants on this very important procedural question arising within the context of the Rome Statute system. Having carefully considered these submissions, the Appeals Chamber decides by majority, Judge Ibanez dissenting, both in respect of ruling orally on this matter and the substance, that the appeals brought by LLV1, LLV2, and LLV3 are inadmissible and must be dismissed as such. The Appeals Chamber finds that LLV1, LLV2, and LLV3 may participate in respect of the prosecutor's appeal by making representations before the Appeals Chamber pursuant to Article 15(3) of the statute. In particular, the Appeals Chamber accepts the submissions by LRV 1, LRV 2, and LRV 3 made in their respective appeals briefs, as well as the submissions for the remainder of the present hearing as representation under that provision. While the Appeals Chamber full reasoning will be contained in the eventual judgment on the appeals, in brief, the reasons of the majority in broad terms concern. Number one, the question as the victim's standing is to be resolved by reference to the chapeau of Article 82(1) of the statute, and more specifically, the provision that either party may appeal certain decisions. Number two, in the view of the Appeals Chamber, who qualifies as a party in terms of Article 82(1) of the statute must be determined taking into account the type of decision that is the subject of the appeal. The meaning of the term either party thus depends on the procedural context. Number three, the decision that is the object of the appeal at hand is the decision under Article 15(4) of the statute, issued in response to the request by the prosecutor seeking authorization of the investigation proprio motu. Number four, victims may participate in the proceedings before the pretrial chamber pursuant Article 15(3) of the statute by submitting representations. Victims, however, do not have the right to trigger proceedings under Article 15. The right is reserved for the prosecutor and is clearly set out in the Article 15(1) of the statute. Number five, in these circumstances, it cannot be sustained that the term party in Article 82(1) of the statute in appeals against the decision of the pretrial chamber under Article 15(4) of the statute includes victims who have made representations under Article 15(3). There is no reason to assume that, while their participatory rights before the pretrial chamber amount to the making of representation before that chamber, the rights are amplified to that of a potential appellant once the pretrial chamber has issued a decision on the prosecutor's request. Number six, the Appeals Chamber does not consider that internationally recognized human rights mandate a different interpretation of Article 82(1) of the statute. The right to an effective remedy arises in the first place with regard to the state that has violated the human rights of an individual. It cannot be a basis for finding that before this court, victims have procedural rights that go beyond those set out in the court's legal framework. Number seven, having determined that LRV 1, LRV 2, LRV 3 are not parties in the terms of Article 82(1) of the statute, they cannot bring appeal against the impugned decision. In these circumstances, the Appeals Chamber sees no need to determine whether the pretrial chamber's decision not to authorize an investigation into the situation in Afghanistan amounts to a decision with respect to jurisdiction or admissibility in terms of Article 82(1)(a) of the statute. And eighth, Judge Ibanez does not consider that this is an interlocutory decision, but that is a judgment that should have been issued in writing, fully reasoned under Article 83(4) of the statute. She considers that the statute and internationally recognized human rights grant the victim standing to appeal a decision issued by a pretrial chamber against the interests of victims, denying a request for authorization to investigate by the prosecutor under Article 15(3) of the statute. Judge Ibanez will file the preliminary reasons in the course of the day. Having rendered our decision, the Appeals Chamber will continue with the schedule for today. As a result of the oral decision just rendered, the schedule for day 3 of the hearing is amended to that effect that the victims will not be permitted to make final submissions as originally planned. Nevertheless, the time allocated for LLV1, LLV2 and LLV3 at today's hearing remains unchanged. The court officer will provide you for copies of the amended schedule for Friday, 6 December 2019. I would now invite the Office of the Prosecutor to address the Appeal Chamber on the merits of the appeals. Your 40 minutes begins now.
Thank you, Your Honours, and good morning to you and to everybody in the courtroom. I'll be presenting the prosecution's submissions on the merits of this appeal. Pretrial Chamber 2 found that there is a reasonable basis to believe that crimes against humanity and war crimes were committed in Afghanistan. It recognised the scale and magnitude of these events. In the period 2009 to 2016 alone, it found that there were more than 50,000 civilian casualties, including 17,700 deaths. The Chamber described what it called brutal and gruesome violence that resulted in, and I quote, devastating and unfinished systemic consequences on the life of innocent people, end of quote, and recurrent targeting of women and very young and vulnerable civilians. That was at decision paragraph 84. It also found that various potential cases arising from these allegations would be admissible at this court. Yet, despite these findings, the Chamber concluded that there were substantial reasons to believe that an investigation would not serve the interests of justice. Why? Because in its view, the prospects for a successful investigation and prosecution were extremely limited. In so deciding, the pretrial chamber in our submission erred both legally and factually. In her request, the prosecutor had found that there were no substantial reasons to believe that opening an investigation would not serve the interests of justice. Virtually every victim application received by the Chamber supported this view. But rather than asking the prosecutor for her view about the prospects of investigation and how this might affect her negative assessment of the interests of justice, in just a few pages and with no express reference to any supporting material, the Chamber unilaterally substituted its own view for the prosecutor's informed, independent and discretionary determination. This is the first time that a pretrial chamber has formed its own independent interest of justice assessment under Article 53(1)(c), and it erred in doing so. Under Ground 1, we say that it erred in law by requiring a positive assessment that an investigation would be in the interests of justice based on factors that were not considered by the prosecution. This is contrary to the plain disposition of Article 53(1)(c) and consistent judicial practice. And under Ground 2 of our appeal, we submit that, in any event, the Chamber abused its discretion in assessing the interests of justice. It did not properly appreciate the factors it considered that is, time elapsed since the crimes, the prospects of state cooperation, and the likelihood of access to evidence and suspects. It considered the prosecution's allocation of resources, which it was not entitled to do. And it gave inadequate consideration to the gravity of the crimes and the interests of victims, both of which are mandatory factors under Article 53(1)(c). Your Honours, these errors flowed from a misunderstanding of the Chamber's role under Article 15. To compensate for the absence of a State or a Security Council referral when the prosecutor acts proprio motu, the Chamber's role under Article 15 is limited to making an independent assessment that the prosecutor's proposed investigation has a genuine and proper basis. In this way, it serves only to prevent abuses of power or unwarranted, frivolous, or politically motivated investigations. And I point Your Honours in that respect to the decision, recent decision in the Bangladesh-Myanmar Article 15 decision at paragraph 127, referring to other Article 15 decisions. In practice, therefore, it's a check by the PTC, by the pretrial chamber, to confirm that the prosecutor has a reasonable basis to proceed, in the sense of a reasonable basis to believe that at least one Article 5 crime has been committed and that at least one potential case would be admissible in terms of complementarity and gravity. It does not require the pretrial chamber to substitute itself for the prosecutor in exercising her limited discretion under Article 53(1)(c), and it certainly does not justify the chamber going further than the prosecutor in looking for additional external reasons to justify the commencement of an investigation. And indeed, in our submission, by overriding the prosecutor's limited discretion under Article 53(1)(c), by speculating about the best allocation of the prosecutor's resources, and by misinterpreting the scope of an investigation, the chamber exceeded its role under Article 15. The drafters of the statute did not intend that the pretrial chamber would manage, much less micromanage, the prosecutor when carrying out independent parts of her mandate. Nor did they intend that investigations authorised under Article 15 be carried out in any different way than investigations resulting from a State or Security Council referral under Articles 13 and 14. I'll now turn directly to answer the questions that you've posed in Group C of the scheduling order. And in your first question, question A, it asks whether the pretrial chamber has the power to consider for itself the factors under Article 53(1)(c) when the prosecutor has requested authorisation for an investigation. The answer is yes, to this extent. When the pretrial chamber receives a request from the prosecutor under Article 15(3), a request to authorise an investigation, it must decide whether to do so under Article 15(4). In this exercise, the chamber must determine, and has the power to determine, whether it agrees or not with the prosecutor's assessment under Article 15(3) and Rule 48 that there is a reasonable basis to proceed with an investigation. And in our submission, this includes all three requirements in paragraph 1 of Article 53, namely subparagraphs A, B, and C. Now, we recognise that opinions on this question vary to some extent, and that indeed a good argument can be made, as the legal representatives for the victims and some amici have done, that the pretrial chamber can only consider interests of justice in Article 53(1)(c) if it's conducting a review of the prosecutor's negative decision not to proceed under Article 53(3)(b). That is, when reviewing the prosecutor's decision not to proceed with an investigation into a situation which has been referred by a state party or the Security Council based solely on interest of justice reasons in 53(1)(c). Now, we do see some merit in this narrow view of the pretrial chamber's powers in relation to Article 53(1)(c). However, this has not been, and we are mindful of the practice to date of the pretrial chamber in the so far 5 other Article 15 decisions in the Kenya case, or in the Kenya situation, in Cote d'Ivoire, in Georgia, in Burundi, and more recently in the Bangladesh-Myanmar situation. In those decisions, the pretrial chamber considered that all of the factors in Article 53(1)(a)(2)(c) fell within the purview of the pretrial chamber's judicial scrutiny. And in addition, if you take such a narrow interpretation of the pretrial chamber's powers under Article 15(4), we believe this would lead to a tension between the content of the chamber's assessment, its assessment under Article 15(4), and the prosecutor's own assessment under Article 15(3) and Rule 48. And this would hardly seem logical given the clear link between those two assessments, both of which are based on the same reasonable basis to proceed standard. In any event, Your Honours, whichever approach you take in this case, whichever one you prefer, it will lead to the same conclusion in this matter. And this is because when the pretrial chamber considers the interests of justice, when it makes its Article 15(4) decision, it does not have the power to go beyond the factors which were considered by the prosecutor in making her Article 53(1)(c) determination. In other words, it must confine its assessment of the interests of justice to the contours of the assessment conducted by the prosecutor. And please allow me what I mean, to explain what I mean by this in practice. It means that if the prosecutor has identified a matter as potentially raising a concern that opening an investigation would not serve the interests of justice, and then weighed that factor against other relevant factors such as the gravity of the crimes and the interests of the victims, then the pretrial chamber, when making its Article 15(4) decision, can decide whether it agrees or not with the prosecutor's assessment. I should say that that scenario has never occurred yet at the court. But if, as more typically occurs, and as has occurred here, the prosecutor has found that there's no specific matter raising interests of justice concerns, the pretrial chamber can then decide whether it agrees with that conclusion. And in this scenario, the prosecutor cannot be expected to have given reasons because, as a matter of common sense, she can't prove a negative. However, the prosecutor can address any particular matter of concern that may arise if she's asked. So, as such, the pretrial chamber's role in this scenario remains a real one. For example, although it's clearly not relevant in this situation, the pretrial chamber might raise a matter which has been identified by the victims under Article 15(3) if, for argument's sake, they had raised concerns that an investigation would not serve the interests of justice. If the pretrial chamber shares those concerns, or indeed has another well-founded concern, then it must inform the prosecutor and, in accordance with Rule 50, Paragraph 4, request additional information and ask for her reasoned view as to whether that concern affects her interests of justice assessment. And once she then provides that assessment, and within a suitable margin of appreciation, given the discretionary nature of the prosecutor's assessment, the pretrial chamber can decide whether it agrees or not with the prosecutor's concrete conclusion. So, in other words, when making its Article 15.4 decision, the pretrial chamber cannot take into account considerations that were not part of the prosecutor's analysis in relation to the interests of justice. And on a separate but related note, the chamber is not required nor even permitted, as it did here, to condition the commencement of an investigation on its own positive determination that this would be in the interests of justice. Your Honours, our position is supported by the text of the statute and the rules. Firstly, it comes from a proper understanding of the purpose of Article 15 and the distinct mandates of the pretrial chamber and the prosecutor. Her Honour Judge Fernandez made this point in her opinion in the Côte d'Ivoire Article 15 decision. She held that because of the limited purpose of the procedure under Article 15 of the statute and the distinct mandates and competences of the chamber and the prosecutor respectively, and I quote from her separate opinions at paragraph 16, the examination to be undertaken by the chamber in exercising its supervisory role is solely a review of the request and material presented by the prosecutor. Rule 48 is also important. This rule, as Your Honours will know, puts the prosecutor's decision-making for proprio motu situations on an equivalent basis as that for referred situations. So when the prosecutor decides whether there is a reasonable basis to proceed, she must consider the factors in Article 53, 1A through C. Now, it's true that Rule 48 does not expressly, in its terms, apply to the pretrial chamber's decision, such as to explicitly link the chamber's assessment to the same factors considered by the prosecutor. But in our submission, it's implicit from this rule, especially when it's read in light of the reasonable basis to proceed standard, which appears in both 15.3 and 15.4, that the pretrial chamber's assessment should not exceed the matters considered by the prosecutor. And Rule 50, paragraph 5 also supports this interpretation. And this is a point which was also made by the pretrial chamber in the Kenya Article 15 decision at paragraph 21. Our position is also based on a proper consideration of the particular characteristics of Article 53.1 itself. In particular, the presumption of investigation, the negative character of the assessment in Article 53.1c, and the function of that provision as a key repository of prosecutorial discretion. And Your Honours need no reminding of the wording of Article 53.1c. As you know, it says, quote, taking into account the gravity of the crime and the interests of victims, there are nonetheless substantial reasons to believe that an investigation would not serve the interests of justice. So this expression of prosecutorial discretion clearly envisages a negative and not a positive assessment by the prosecutor. If the pretrial chamber were to consider the factors for Article 53.1c, which were not referred to in the prosecutor's Article 15.3 request or later when asked, effectively it would be substituting the prosecutor's discretion for its own, which would be impermissible, and if it were to insist on making a positive assessment of this factor, this would conflict with the presumption of investigation in Article 53.1 and the negative formulation of subparagraph C. And both of these were deliberate choices made by states when drafting the statute. I'll turn now to question B, your second question. This asks whether the factors considered by the pre-trial chamber in its decision at paragraphs 91 to 95 are appropriate factors for an interest of justice determination. For its interest of justice assessment, the chamber considered factors which it called or found particularly relevant to whether the investigation prospectively appears suitable to result in the effective investigation and subsequent prosecution of cases within a reasonable time frame. It considered firstly the time elapsed between the alleged crimes and the request, which it assessed as significant. That's at paragraphs 91 to 93. It assessed the prospects of securing meaningful cooperation from relevant authorities in the future, which it gauged as, quote, even trickier, end of quote, than the already what it called scarce cooperation obtained by the prosecutor in the preliminary examination phase. That's at paragraphs 91 to 94. And thirdly, it considered the likelihood that relevant evidence and potential suspects or potential relevant suspects might be available and within reach of the prosecutor's investigative efforts and activities, something it found wanting. This was at paragraphs 91 and 94. And finally, it considered that an investigation would result in what, in its view, the prosecution having to reallocate its financial and human resources, which, in its view, would compromise the prosecutor's other preliminary examinations, investigations, and cases with more realistic prospects to lead to trials. That's at paragraph 95. And you've asked whether it was appropriate for the pre-trial chamber to consider these factors. Our primary position is that since the prosecutor did not consider these factors to be relevant for her interests of justice assessment in her Article 15.3 request, and since the chamber did not seek to ascertain the prosecutor's views on these matters, any positive assessment in this regard was inappropriate, no matter the circumstances. But in any event, the factors taken into account were, in our submission, inappropriate, given the facts of this situation. Now, in its policy paper on the interests of justice, the Office of the Prosecutor has stated that it considers that the only factors which, as a matter of law, must be taken into account for Article 53(1)(c) are those expressly set out in the provision, the gravity of the crimes and the interests of the victims. Beyond these, and exceptionally, on a case-by-case basis, the prosecutor may, in her discretion, consider other factors, provided they arise concretely from the facts of the situation. But the interests of justice cannot be transformed into a catch-all provision requiring the prosecutor to be satisfied about an indefinite number of additional matters before an investigation can be launched. The situation is quite different once an investigation is opened. Once this happens, a host of evidentiary, normative, and operational factors will require the prosecutor to select and prioritise the particular incidents, suspects, and charges she wishes to focus on for the purpose of bringing cases before the court. At that stage, factors relevant to the feasibility of an investigation and operational issues, such as prospects for cooperation and access to evidence and suspects, or even the office's budgetary resources, may be highly relevant. And I point your honours to the Office of the Prosecutor policy paper on case selection and prioritisation, in particular paragraphs 13 and 51. But these factors should not be, as it were, front-loaded into the preliminary question of whether an investigation should even be commenced. Now, the prosecution need not take a position in the abstract on whether the first three factors considered by the pretrial chamber were appropriate or not. What we can say is that when considered in light of the concrete facts of this situation, they were not appropriate. In other words, the chamber should not have taken into account what it understood to be the lengthy time elapsed since the crime, or its view of the limited prospects for state cooperation or access to evidence and suspects. That's because these factors did not genuinely arise from the facts of the situation when properly understood in light of the applicable law. We have explained this in our appeal brief at some length, taking up quite a few paragraphs, at paragraphs 111 to 138, and I won't repeat those submissions. Safe to say that, in particular, the Chamber's view of their relevance, of these factors, apparently focused on just one of the three potential lines of inquiry in the situation, overlooked the statute's legal framework for cooperation once an investigation is authorised, and speculated about the prospects of securing evidence and suspects without an adequate factual basis. And as such, the pretrial chamber should not have considered those matters. Finally, as for its consideration of its view of how the prosecutor should allocate her financial and human resources, first, while the prosecutor must indeed consider her human and financial resources when prioritising which cases to pursue, that's something that appears in our case selection policy on paragraphs 11 to 12, it is unclear whether she can ever validly consider resource considerations when making her decision under Article 53(1)(c). But more pertinently to this appeal, the management and administration of the prosecutor's resources is exclusively a matter for the prosecutor under Article 42, and as such, the Chamber's consideration of this matter was not just inappropriate, it was ultra vires. Finally, Your Honours, I turn to your last question, question C, which asks if a pretrial chamber, in deciding whether to authorise an investigation, may limit the scope of the investigation to incidents specifically mentioned in the prosecutor's request and authorised by it. And the answer in our submission is no. The purpose of an Article 15 decision is to set out the parameters of the authorised investigation, its outer scope, not to define the specific incidents within it. The scope of an investigation is delimited by suitable temporal, geographic, or other material parameters. A decision by the pretrial chamber to limit the scope of the authorised investigation to incidents specifically mentioned in the prosecutor's request would inevitably and improperly intrude into the prosecutor's independent duty to conduct an objective, evidence-led investigation and to select cases for prosecution. And I also note that this approach departs from how all other pretrial chambers in the other Article 15 decisions have approached the issue, in Kenya, in Cote d'Ivoire, in Georgia, in Burundi, and most recently in Bangladesh, Myanmar. And there are several reasons for this. First, the preliminary examination procedure is not intended to identify exhaustively every crime which might form part of an investigation. Limiting the scope of the investigation to the specific incidents in the prosecutor's Article 15(3) request would conflict with Article 53(1)(a), which requires that the prosecutor, find a reasonable basis to believe that a crime within the jurisdiction of the court has been committed. Indeed, it's sufficient to show that at least one crime, at least one Article 5 crime, has been committed. The prosecutor prosecutor may, of course, choose to provide multiple examples to illustrate that the standard has been met, but her early and non-comprehensive identification of incidents should not be seen as setting the parameters of the situation. And this brings me to a matter raised by counsel for the cross-border victims yesterday. Mr. Powell's raised as problematic the fact that the prosecution did not include a reference to crimes against cross-border victims in her Article 15.3 request, and nor has she formed, in his words, a definitive view about them. And his concern, in fact, raises precisely why the scope of an investigation cannot be limited to the specific incidents in the Article 15 application. We've explained this in our response to the amicus curiae brief at paragraphs 17 to 21, and Mr. Gariglia yesterday touched on this when he responded to Judge Hofmansky's question. We did not, we cannot, and we're not required to exhaustively identify all possible criminal incidents in our Article 15 request. The cross-border victims are not the only victims of alleged crimes who were not specifically addressed in our request. Indeed, in the application itself, in the Article 15 request, we expressly reserved our position in relation to other potential incidents. That's in paragraph 38 of our request. But this does not mean that these incidents cannot potentially be included, so long as they fall within the scope of the investigation based on temporal, geographic, or other material parameters. And indeed, any decision on whether, by the prosecutor, now on whether the prosecution will investigate and prosecute them will depend on several factors and can only be decided based on our independent, evidence-led investigation and other matters relevant to case selection. In fact, to do so now would be akin to making an Article 53, paragraph 2 determination, which would clearly be premature. If the pretrial chamber were allowed to limit the scope of the investigation to the specific incidents, it would essentially require the prosecutor to prove each incident to the Article 53.1 standard. And this would raise several practical concerns. For example, some crimes that require more intensive investigative methods in order to establish them would be less likely to be investigated and prosecuted. This could include, for example, crimes with more complicated elements or even conduct of hostilities crimes. The prosecution doesn't have the same investigative powers in a preliminary examination as it has once an investigation proceeds. So for some crimes, it would be harder to meet the standard in Article 15, paragraph 3 and Article 53.1. Also, if the prosecutor were restricted to incident-focused investigations, when she inevitably, as she will, come across evidence about other criminal incidents, she would have to go back to the pretrial chamber with a new Article 15 request in order to investigate them. Your Honours, I asked you to think about a situation. What if the first witness the prosecution comes across mentions a mass atrocity which was not known before? It can happen. It happens often in criminal investigations. The prosecution would have to go back to the pretrial chamber for a new authorisation. This would be an overly burdensome procedure. It would apply only for proprio motu situations, and it would be impractical, and it could lead to partial or incomplete investigations. And in the meantime, evidence could be lost. It could also potentially compromise the prosecutor's ability to effectively identify and pursue exculpatory evidence. Secondly, limiting investigations to specific incidents would, in the majority of cases, collapse the distinction between situations and cases. The pretrial chamber would not only play a role in authorising an investigation into a situation, but effectively would be directing the prosecution to certain incidents and preventing it from pursuing and selecting a particular case. In other words, the chamber would effectively be directing the investigation and the case selection. This would undermine the prosecutor's independence, her obligation in Article 54(1)(a) to investigate incriminating and exonerating circumstances equally, and her discretion and duty to conduct evidence-led investigations to decide which incidents and which persons to proceed against. Finally, Your Honours, it would lead to the untenable outcome that different standards apply to investigations for referred situations and for proprio motu ones. For the referred situations, the state or the state party or the Security Council refers the situation as a whole to the prosecutor for her to decide which cases to pursue. But for proprio motu situations, if this were the case of incident-specific investigations, the pretrial chamber would effectively direct and guide the investigation and the case selection.
Excuse me, counsel, you have 5 minutes left.
Thank you. This dichotomy has no basis in the statute, and it would give the pretrial chamber a role in supervising the investigation, something the drafters expressly rejected when crafting the model for this court. The safeguard, rather, lies in the prosecutor's duty under Article 54 to conduct objective evidence-led investigations. And this duty is always applicable, no matter the trigger which led to the opening of the investigation. Your Honours, this concludes my submissions. Thank you for listening.
Thank you, Mr. Brady. And then I will ask the representative of the Islamic State of Afghanistan. You are invited to address the Peace Chamber. You 40 minutes begins now. Please proceed.
Thank you. Mr. President, Your Honors, the government of the Islamic Republic of Afghanistan is honored for the opportunity to address the Peace Chambers on these very important matters for the future of our country and all of our people. Our nation has tragically been engulfed by armed conflicts and violence for far too long. In recent years, they have been particularly bloody and divisive as extremist terrorist and repressive groups have sought to tear our great country apart. From the Soviet communist regime to the Taliban and now ISIS as well. The scars from these conflicts run very deep. Every family, every child in our country has been harmed by the hundreds of thousands of gratuitous attacks on civilians. So many ordinary lives have been wrecked forever. It is a truly sad and distressing human history. This is our daily experience, and one that we as the government are more determined than ever to change and to stamp out the criminality that is rife in our society. We all ardently share with the ICC, the prosecutor, and with all of the victims the commitment to end impunity and achieve justice. We especially welcome the strong participation of the victims in these proceedings. The decades of conflicts have devastated our country and its economy, and we remain a country still at war. In its last quarterly report, the United Nations Assistance Mission in Afghanistan recorded that for the 6th year in a row, it had recorded more than 8,000 civilian casualties in the first 9 months of this year. We are fighting adversaries in the Taliban and other terrorist groups who do not hesitate to target civilians and to target anyone connected with the government, including the police, the prosecutors, and the judges going about their work. It's a grim picture in which each day is a struggle to control our country and protect our children for the future. Despite all the subversive efforts of our adversaries, no one can take away our belief and resolve to hold those most responsible to account. The government of Afghanistan is positively pressing ahead with ambitious reforms, and our commitment to criminal justice is at its heart. We ask the court to look at what we have achieved in the area of criminal justice for international and terrorist crimes. We have reformed our national criminal laws so that torture and other international crimes are properly addressed. We have built up the institutional capacity of the courts and prosecutors. We have established a dedicated international crimes office. We have many thousands of investigations and prosecution underway. We are engaging fully with the international human rights mechanisms. My government is doing all this while prioritizing peace building to end the current violence and suffering and for the long-term national interest for our country. Peace and justice are certainly not contradictory as the UN has recognized, Afghanistan must be given some latitude to achieve peace first and foremost for the victims of the violence. And in order to allow for justice and reparation to follow, this consideration must be taken into account by the ICC because the authorization of an ICC investigation, which we oppose, would jeopardize both national and international efforts to forge peace. Our national investigation will continue and be expanded. Your Honors, the government of Afghanistan has cooperated constructively with this court and with the prosecutor in particular. We have provided documents and information. We have invited the Office of Prosecutor to come to Afghanistan. In 2017, the office declined our invitation, citing security concerns. That is relevant to your honors because many Afghans, including those who have suffered profoundly as victims, will ask how this court could investigate these crimes better than my government if the prosecutor is unable to visit Afghanistan to carry out those investigations. We can undertake the necessary investigations in our own country. We are doing it right now against the odds. My government, my country implored the court to look at what Afghanistan has achieved. Look at our starting position severely weakened by decades of conflict. Look at the immense challenges after the first democratic transfer of power in our history. Look at how far we have already advanced in a short period of time in spite of all these obstacles. we are actually aware that there is a distance left to travel. We know that we need to do much more. But considering where we started after the removal of Taliban, considering the impediment we continue to face, no one can say that the government of Afghanistan is not genuinely seeking to bring justice to the victims by investigating and prosecuting these matters in our own country. We urge the court to recognize and encourage our good faith and fearless efforts that would truly benefit our country and the alleviation of the misery our people endure. It would serve the interests of justice. I will now hand over to my counsel for the government to set out our legal submission. Thank you.
Thank you very much. Please, counsel, continue.
Mr. President, Your Honours, when the decision of the pre-trial chamber to refuse the prosecutor's application to open an investigation was handed down, it is no secret that it was greeted with widespread howls of criticism, especially given the timing when it was delivered. It was hard to find too many, particularly in the international justice community, who thought the decision was justified. What was, however, perhaps most surprising was that it was equally hard to find too many asking about the current ability of the national criminal justice system in Afghanistan to investigate the most serious international crimes, or what could be done to help the national jurisdiction. The chorus of criticism deflected attention away from the present steps that are being taken within the country itself. It was simply assumed by many, without any scrutiny, and wrongly we say, that Afghanistan is a failed state, unable to act, and to be written off as an unreliable partner. A view that is totally unfounded and unwarranted. The submission on behalf of the government of Afghanistan in this appeal is thus to set the record straight and to ensure that the focus of many of those outside Afghanistan who peer momentarily into it should not be all about how the pre-trial chamber got it wrong, but on what the state party itself is doing and its true potential to do more in the future, especially if it is supported by the ICC and the prosecutor. Your Honours, the government submission rests on two key propositions. The first is that the scope and quality of the national investigations and prosecutions is clearly a relevant factor to be taken into consideration when assessing whether there are substantial reasons to believe that an investigation would not serve the interests of justice. And secondly, that in the present circumstances, there is no need to authorize an ICC investigation at this stage. And I underline at this stage. In light of the investigations being undertaken by Afghanistan under its new laws and new criminal justice bodies and mechanisms put in place precisely to investigate the same crimes that could come before the ICC. That would, far from undermining the interests of justice, we say promote these vital interests, and in particular those of the countless traumatized victims. And we heard yesterday from the NGOs from Afghanistan, very helpfully, who informed us that it is at least 69% of a population of 35 million people. The plea of Afghanistan is for the fundamental principle of complementarity to be given full effect. The nation must be given the opportunity to continue its investigations and strengthen them in light of the severe obstacles that are faced on the ground, with the support of the court. And very importantly in that regard, to be, as Afghanistan, reporting back to the court on its progress each step of the way so that the position can be constantly assessed. Afghanistan wishes to embark on this course hand in hand with the court. It is not in any sense a competition. Instead of authorizing an investigation that could be open for many years, realistically, without any major movements, and I say this recalling that the preliminary examination has itself lasted 11 years, rather focus all the attention and resources on the national initiatives that are already underway, which would benefit from the court's support. Of course, always with the backstop of being able to refer the matter back to the ICC if that were necessary. We submit it would send a very powerful message to the country that the national justice system was legitimate in the face of some of the very worst terrorist attacks the world currently has to confront, that it was worthy of promotion and thus possessing the force of genuine deterrence as part of rebuilding the nation. I will deal, Your Honours, with each of these arguments, and then I have a few submissions lastly about the scope of the pretrial chamber's powers. Firstly, the interest of justice. This is obviously a core concept that arises throughout the work of the ICC and indeed in all of our national legal systems. In the present context, the specific issue that arises is whether there are substantial reasons to believe that an ICC investigation would not serve the interest of justice. Now, Your Honours, to make that determination, whether there are substantial reasons, logically we need to know what are the interests of justice. It is a negative definition, but really what we focused on here is, are there substantial reasons? That's a very clear and positive matter that has to be addressed. Now, a typical definition of the interest of justice, which emerges in both national and international systems, is that it is the proper view of what is fair and right. It's not susceptible to a precise definition. It can't be applied mechanically. It requires a very broad evaluation based on an assessment of the particular circumstances of individual cases. That is what defines it. It is extremely broad, all-encompassing. Perhaps the apt word is all-inclusive, which is a positive characteristic we highlight. Now, given that manifest breadth, and by the very nature, the actions of the national criminal justice system must be a consideration to take into account when evaluating the interests of justice. And whether there are then substantial reasons that it would not be in the interest of justice to proceed. The prosecutor's own policy paper on the interest of justice of 2007 says that other potential considerations include other justice mechanisms, and the paper endorses the complementary role played by domestic systems, rightly so, at pages 7 and 8. Also, in the preliminary examination report of 2017 on Afghanistan, in respect of the interests of justice, paragraph 275, the OTP takes into account, and I quote, the limited prospects for accountability at the national level as a factor weighing in favor of an ICC investigation. Now, we said the reverse must obviously also be true. Furthermore, the obstacles faced in an investigation also must be a relevant factor. There's hardly a day, Your Honours, that goes by when national police forces around the world do not consider whether they have lines of inquiry that would reasonably permit an effective investigation that could lead to a prosecution, especially in the context of extraterritorial and universal jurisdiction cases. And if there are not such leads, then they could be entitled to investigate no further. And we all know that in all states, in prosecutors' offices around the world, they consider the public and national interests in deciding whether to proceed to bring a case or not. And in exceptional circumstances, they may decide not to prosecute. These considerations are magnified in conflict and post-conflict scenarios, like Afghanistan. But it does not mean, and I must stress this for a minute, that Afghanistan is not committed to bringing justice. There are simply vital interests of peace that must be prioritized and then taken into account by your honors, because immediate civilian life must be saved, and to create the conditions to allow justice to take its course. Afghanistan notes that the pretrial chamber rightly identified certain fundamental hurdles in any investigation. And similar outreach problems were identified yesterday by the NGOs from Afghanistan. No presence of the registry and services on the ground was mentioned. As the government, we know better than most about these hurdles, as the government faces them in the harshest form each day. The government's submission, however, is that it is taking them on. They are finding ways at the coalface to overcome them. And that should be acknowledged, as it provides the best chance of justice here and for the victims. And further, as the OTP submitted repeatedly yesterday, Article 15.5 allows the OTP to apply at any time to authorize an investigation. It is not game over if Afghanistan was allowed their rightful opportunity. That leads me into the second proposition in relation to our national investigations. Our submission today, Mr. President, Your Honours, is not a complementarity challenge per se, whether preliminary under Article 18 or under the specific provisions of Article 19. Now, Your Honours may well be thinking, well, why don't you go ahead and make such an application if you wish to? And the government certainly reserves such a right. But we are where we are today, and it is thus entirely appropriate for the government to be urging Your Honours not to authorise an ICC investigation for now. Why authorise it, even if there are errors below, when the state party comes before you submitting that it is genuinely investigating? Why rush in when the national jurisdiction is already taking on the immense challenges, as they certainly are in Afghanistan, of investigating and prosecuting international crimes? And it is for all these reasons that the government has elaborated in its written submissions what the national system is actually doing. And we're ready to provide further details, whether publicly or confidentially, if it concerns sensitive matters that could assist the court. And I highlight here, just by way of illustration, the special and dedicated International Crimes Office established in May of 2018 to specifically investigate the same potential crimes that could come before the ICC. It is an office consisting of 20 prosecutors under a chief prosecutor and 20 other staff members that report directly to the Attorney General. It applies the newly amended Afghan Penal Code, which came into force in February 2018, which covers all ICC crimes and incorporates as well command responsibility, thus further permitting the investigation of those most responsible. The International Crimes Office is actually, in the past year, investigating both Afghan and Taliban cases involving international crimes. One example being the notorious Zormat case, in which 11 civilians were killed by Afghan security forces, allegedly, in the southern province of Paktia. There are many other cases in other provinces where the office is able to gain access and investigate. Alongside that, the Office of Prosecution for Internal and External Crimes of the Attorney General's Office has in the past year referred over 1,500 cases involving international and terrorism crimes to the national courts. And there are many other thousands of cases being investigated. And we also highlight in our submission the Commission on the Prohibition of Torture body that was formed in April 2017 following the new law. And, Your Honours, there is certainly no blanket amnesty for international crimes in Afghanistan. The pretrial chamber simply got this wrong when they referred to amnesty laws to find the case admissible before the ICC. The prosecutor had rightly pointed out that victims can bring cases in their submission. That was at paragraph 272. The pretrial chamber completely overlooked that and simply highlighted the amnesty law in finding the case had to come before the ICC. That's paragraph 74. In any event, Your Honours, what we are submitting here is new information, bearing in mind that the OTP applied to open an investigation in November of 2017, and the pretrial chamber's decision is based on that information going back. Much, we say, has advanced since then, and if this is all new evidence, we have an alternative submission, which is that it can be sent back to the pretrial chamber, which I'll address, Your Honours, on briefly at the end. And what's more, Article 15.4 says any findings on jurisdiction and admissibility are preliminary in any event, and such findings are without prejudice to future determinations, thus taking into account the evolving assessment that the court must undertake of national investigations when it comes to complementarity. It's not fixed in time forever. The United Nations in the past year has given considerable credit to the Afghan authorities, which we would urge Your Honours to take into account. The UN in April of this year welcomed the concerted efforts of the government and took note of the progress made in the implementation of its national plan and the elimination of torture. And the UN Human Rights Council as well, in the Universal Periodic Review for Afghanistan, noted the solid commitment of Afghanistan to promote and protect human rights. These are just some examples. The victims are, with respect, thus wrong to say that Afghanistan is unable to investigate and just to bat it aside as though none of this evidence has any effect, and that it is open to question whether the government is even willing. In fact, it's quite remarkable that in all the submissions we've heard, no one has made any submissions about what the state has been doing, particularly in the last year, given it any recognition or credence at all. Alternatively, Your Honours, the government submits that if the appeals chamber is not inclined to follow this course, if there are errors to be addressed from below, or if there are any other reasons, then we asked that the matter alternatively is remitted back to the pretrial chamber to consider in light of all the government's information and submissions. In that way, Your Honours' decision can then be applied through usual rules of precedent by the pretrial chamber in light of all the new relevant submissions, as also in light of hearing from the victims further. We noted the complaints yesterday about victims not having sufficient time to engage with the pretrial chamber in the first instance, and also to address the interests of justice test itself on the available evidence. The OTP this morning highlighting that particular problem, that they'd not been given a chance to be heard. Well, this would be the opportunity to be heard alongside the state most directly affected. And that's why we put it forward as an alternative practical solution to the problem. Your Honour, on the subject of the powers, very briefly, of the pre-trial chamber, the government submits that under the express terms of Article 15.4, the chamber absolutely has the power to consider and decide to open an investigation if there's a reasonable basis to proceed. And equally, to decline the prosecutor's application if there's no such basis. That means if there are substantial reasons not to investigate, these must be matters the chamber can examine and decide on, in the same way that it considers jurisdiction, admissibility, the interests of victims, and any other relevant matter. The Kenya decision has been cited, paragraph 21. The standard under 15.4 is exactly the same as that under 53.1. And this is what pre-trial chambers have done in all situations. They've considered the OTP's position. They've looked at the interests and submissions of the victims and then decided whether or not there are any substantial reasons, nevertheless, not to proceed. There is no detailed analysis in many other cases because in those cases the chamber found that there were no substantial reasons. If they had, there's no doubt would have been much more discussion of the issue. We say this is a straightforward matter. It is an application process by the OTP in which the chamber decides, like in any other application, whether the requirements are met. It should not be confused with the chamber's separate and specific powers of judicial review of a decision by the OTP when the OTP has decided not to investigate in the interests of justice. This particular review power provides an additional check on the OTP when it refuses to investigate. In our submission, the OTP this morning has overcomplicated the position entirely in trying to carve out some test that would allow for the chamber only to confine its assessment to that assessment conducted by the OTP. If they got the issues on the interests of justice wrong, then the chamber is fully within its right to say that. In exactly the same way, if they got admissibility wrong or jurisdiction wrong, the chamber makes a ruling on the application that is made. And this is very effectively highlighted in the recent Bangladesh decision, paragraph 113, where the court says that the prosecutor has identified no reasons not to investigate, and the chamber has no reason to disagree with this assessment. So it takes what the prosecutor says, it takes what the victims say, it looks at the matter and says there's no reason to disagree. If the prosecutor has overlooked something, as if it had happened in admissibility or jurisdiction, the chamber would be fully within its rights to say, sorry guys, you overlooked this point. And that is a matter, therefore, that means you cannot proceed. It's no different to any other application that comes before Your Honours. The prosecutor has to satisfy the requirements. The court is empowered to assess whether they've done that or not. Your Honours, my concluding remarks and relief. There is at the heart of the pre-trial chamber's decision a sincere concern about how long these proceedings have gone on for, with no end in sight, like many others at the ICC. 11 years just to decide whether even to investigate. On any view, Your Honours, this must suck away the hope and belief of any victim. So there is an understandable, very real anxiety here that the pre-trial chamber has placed its finger on. Whatever view is taken on how it has expressed that, our request is that the appeals chamber engage fully with this crux issue. It will hopefully be evident to Your Honours that what Afghanistan places before you in its main request or alternative is a very sensible and appealing, practical solution. We must emphasize that this approach to the problem can also provide the foundation for the ICC to engage with other states who have been specifically mentioned in this hearing under complementarity. The court would be clearly seen to reach out the long and respectful arm of complementarity and thus encourage national action as partners with the ICC. Of course, always with the caveat that the ICC can return to the frame in full. You may be able to find reassurance in the often quoted statement that the absence of trials before the ICC would be a major success, thus implying that national investigations and trials were taking place in the jurisdictions concerned. It is time, we say, to bravely grasp the nettle and decline to authorize an ICC investigation, contrary to what the ICC is probably now expected to do, and instead unleash the authentic potential of Afghanistan's national institutions with the assistance of the ICC. Help the country. Don't question it, don't denounce it. In this way, the hundreds of thousands of victims will have their own police inquiring into their cases now, appear before their own courts now, and see and test justice happening before their very own eyes now. And they will know the ICC stands in steadfast support and always as a safety net for international justice. Afghanistan, as a state party wholly dedicated to the ICC, urges for a sound and prudent approach, and one that we say lies at the very center of the ICC's existence and future. Thank you, Your Honours.
Thank you very much. Thank you for being on time. We will adjourn now for 30 minutes and resume at 11:30, which time we will hear from the council, from the legal representative of victims, beginning with Group 1. Thank you very much.
All rise.